This is Barry Zalma speaking for Claims School Incorporated's blog, Zalma on Insurance. Today we're speaking about why it is not nice to name a defendant only to avoid federal court, and why a fraudulent joinder of a defendant to avoid federal court will fail invariably if there is no real case against the new party. It never pays to sue a party who did nothing wrong. The plaintiffs in a case against State Farm initiated an action in state court asserting claims for breach of contract, bad faith, and constructive fraud, negligent misrepresentation against State Farm. They also brought claims for negligent procurement of insurance and constructive fraud against Tyler McCall and Tyler McCall Insurance Agency. In the case entitled Justin Gamble versus State Farm Fire and Casualty, the United States District Court for the Western District of Oklahoma on July 2, 2025, dealt with the motion of State Farm to remove that case to federal court and to deal with its allegation that the McCall Agency fraudulently were joined to avoid removal to federal court. The key issues started with fraudulent joinder. State Farm removed the case, arguing that Mr. McCall and the McCall Agency were fraudulently joined to defeat diversity jurisdiction. The standard for establishing fraudulent joinder is stringent, requiring either actual fraud in the pleading of jurisdictional facts or the inability of the plaintiff to establish a cause of action against the non-diverse party in state court. Or 2, negligent procurement of insurance. Plaintiffs alleged that the McCall Agency negligently failed to procure insurance coverage they requested. However, the court found that the plaintiffs received the policy they requested and had sufficient coverage to replace their roof. Therefore, they cannot show that insurance was not procured as promised. 3, constructive fraud or negligent misrepresentation. Plaintiffs also alleged that the McCall Agency engaged in constructive fraud and negligent misrepresentation by failing to disclose information about State Farm's bad faith claims handling tactics and its Hail Focus initiative. However, the court found no viable claim against the McCall Agency for these allegations. State Farm therefore removed the case, contending that Mr. McCall and the McCall Agency were fraudulently joined, and their non-diverse citizenship may therefore be disregarded for purposes of establishing diversity jurisdiction. The standard for establishing that a defendant has been fraudulently joined is a difficult one, where the removing party must demonstrate either 1, actual fraud in the pleading of jurisdictional facts, or 2, inability of the plaintiff to establish a cause of action against the non-diverse party in state court. The standard to establish fraudulent joinder is more exacting than for dismissing a claim and requires all factual disputes and all ambiguities in the controlling law to be resolved in the plaintiff's favor. However, where a defendant's non-liability is established as both a matter of fact and law, the defendant's joinder is fraudulent and remand is appropriately refused. The McCall Agency is the State Farm Insurance Agency that sold plaintiff the insurance policy. Oklahoma law recognizes that an insurance agent has a duty to act in good faith and use reasonable care, skill, and diligence in the procurement of insurance. An insurance agent can therefore be liable to the insured in negligence if by the agent's fault insurance is not procured as promised and the insured suffers a loss. However, the scope of the agent's duty to use reasonable care, skill, or diligence in the procurement of insurance is limited to needs disclosed by the insured. Agents do not have a duty to advise an insured with respect to his insurance needs, and a general request for adequate protection and the like does not change this duty. It is clear from plaintiffs' allegations and the record that plaintiffs received the policy they requested and had sufficient coverage to replace their roof. No viable claim against McCall is available because plaintiff's claim against State Farm depends upon what damage her roof sustained, not the terms of her policy, and as a result, plaintiffs had no possibly viable claim against the McCall Agency for negligent procurement of insurance. Any implied representations by the agent about the property's condition or its eligibility for a replacement cost value policy were either true or not the cause of plaintiff's loss. Mr. McCall and the McCall Agency were fraudulently joined defendants, and their citizenship is therefore disregarded for purposes of determining subject matter jurisdiction. So the claims against Mr. McCall and the McCall Agency were dismissed without prejudice, and the case will remain in the USDC. In my opinion, some litigants do not like litigating in federal court, especially when they are suing insurers, and will sue the agent to create a failure of jurisdiction in federal court. Sometimes they'll sue an insurance adjuster or anybody else that they can conceivably find a nexus with their claim. The plaintiffs tried and failed because the agent did exactly what he was required to do. He bought them the policy they asked for, and therefore the case will be tried against State Farm in federal court and will not go back to the Oklahoma State Court. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. Please tell your friends and colleagues about this blog so that they too can subscribe. It's, as are these videos on YouTube and rumble.com, free. If you do watch these videos, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in further detail about insurance claims, insurance law, and insurance fraud, please consider subscribing to my Substack publication. Thank you for your attention.